Welcome to commercial law. Assuming you're here to do commercial law. Yes? Yes, okay, so nods. Good, perfect. My name is Magda Raczynska, and I'll be doing some of the lectures in commercial law with you this year. I will do the majority of Term 1 lectures, and I will introduce those who will be doing the lectures later on when I explain the format of the module. But before we start talking about those introductory details, which are perhaps less exciting, first of all, let me apologise for my voice. I've picked up some cold, so I hope you can hear me okay. Can everybody hear me okay? Good. The other thing is, I'm not entirely sure whether there's LectureCast in this room or not. Definitely a Hoover next door. Oh no, it's not Hoover. It's anyway, it is. So just in case it's not being recorded on LectureCast, I'm recording it on my phone. And if that trend persists for next year, I'd appreciate your help reminding me to put my phone on to record it, okay? But I'll check whether there is a LectureCast working here or not. So you're here to do commercial law, and you might have still some preliminary questions, such as, why am I here? Why do commercial law? Why is this a good idea? And there are very good reasons for doing commercial law. Some are practical, some are academic. So commercial law is the finest example of English common law, and I stand by this view. English common law has proved immensely successful over the past few centuries in governing commercial law disputes, business party disputes. And it can be empirically measured. Don't take my word for it. It can be measured by looking at the sort of law that parties choose to govern their contracts when they enter into a deal with one another. They choose they choose English law, but they also choose England, UK, as the place where they want to litigate their disputes if it's necessary. So that says a lot about the importance that English law plays worldwide. And it's worth noting that English law has not developed through a code. So code is something that it's a big statute. You might have come across it if you are familiar in any way with civilian jurisdictions on the continent, for example in France or Germany, but also in the States. The Uniform Commercial Code, for example. Has anybody studied civilian jurisdictions or US? In those jurisdictions, the law, commercial law, civil law, law governing private law disputes, is set out in a big statute. It's not essential that it is big, but it's big because it is comprehensive. The idea is to set out legal norms in a way that's systematic but also hierarchical. So very often you will have a general part and specific part governing specific contracts, for example, sale of goods, leasing, hire purchase. You will have section on property law, but apart from that you will often have the general parts governing legal relations in general.
So you're saying that in those jurisdictions it's mainly statutory rather than here that big developments are in case law?
That's right, that's exactly what I'm saying. The importance of statute is much greater on the continent, but also, interestingly, in the US and also countries that followed the US suit, a lot more codified law. And there are various reasons for having adopted statute rather than being based on precedent, as is the case in the UK. And we're not here to discuss those reasons, but what's interesting, I think, is that unlike on the continent or in the States, for example, where there is a code, English law has not developed in accordance with set out, pre-thought, intellectually worked out principles that were set out by intellectuals, very often law professors, For example, the French Civil Code, which was drafted in the early 19th century, was drafted as a big book like this, and it was drafted by only 4 law professors. It does have some flaws, of course. It doesn't mean that every civil code has to be drafted in this way. The Uniform Commercial Code in the States, which is a much greater statute and covers a wide variety of areas in detail, has been put forward by a group of academics but also judges and practitioners, and it's regularly kept up to date with their help. So it's true that in civilian jurisdictions, unlike in England, principles are set out in a different way. But there is a potential benefit to English law because of it not being based primarily in statute, not being set out in a code governed by those general principles. What's the advantage of precedent-based system?
Incremental ad hoc development, because it might be more difficult and time-taking to get a bill through Parliament, rather than just having a case and a judge makes a decision. Absolutely.
It's very easily, it's quite flexible. You end up looking at the commercial dispute at hand and adjusting the principles, if you like, excuse my the language, to what the commercial parties need. So it's practice-oriented. It's not led by grand principles set out by law professors. It's not intellectual, if you like. You can think of English law as being a complete intellectual desert in that sense. But it's very practical. And you might think that, is it good for commercial parties to have a precedent-based system? You have the flexibility, that's true, but what else do commercial parties like, do you think, business parties?
Certainty.
Yeah. So in what ways is the precedent-based system not so good for certainty, potentially?
Well, you've got Oliver Wendell Holmes' predictive theory, so law is just a matter of what the courts will do in fact. So there's that kind of idea that you have to predict the whim of the judge, respectively.
Absolutely. Absolutely. So there are problems, potential problems with precedent, but in practice, over the centuries, the judges have shaped the law in such a way that by now the developments have achieved a level of certainty on the level of high principles as well. So it's unsurprising that commercial parties do frequently across the world choose English law to govern their contracts, and they do choose to litigate here. English law is thought to be fair and predictable, despite the fact of being based on precedent. You might query whether it's very clear in the sense of being easily discoverable, very transparent. It's not so easy to find precedent unless you know where to look for, unless you're skilled and trained. There's a greater role of lawyers, perhaps, in that respect. But equally, on the continent, you might argue, codes are not so easy to read either. Did we have any questions so far?
So the codes, they draft an initial code and then they add supplements, as you would a textbook?
Good question. It varies between jurisdictions, and I can't speak for every single jurisdiction, and majority, I think it's fair to say that majority of jurisdictions in the world have codes in one form or another. And indeed, even English law has a big statute in the form of Companies Act, and I would argue that's a form of code. It's a big, comprehensive statute. But by and large, in those jurisdictions where the majority of the law, especially applicable to private law, is in codified form, the statutes need to be updated. So it's either done by Parliament, which takes time, probably not as much time as it does in England. That's my observation. That's not necessarily a good thing, because legislation is just churned out very quickly, not necessarily thought through, and there are problems. I do remember some cases where there's a media case and the word "and" appeared all of a sudden, where comma ought to have been, or vice versa, and it does change the meaning. So it does have its problems. The other way is to have a commission, such as in the US.
Sorry, I know that in the EU they delegate some legislative power directly to the Commission, so they can essentially legislate without going through the normal route. I believe you sort of give the power totally to the technocrats, and I was wondering maybe that happens with the supplements or the Code Civil to make it quicker, more quicker, updated.
Okay, so that's yet another point here. So the point here is about the role of EU, I think. It's a much broader question. But to answer the specific question, the role of the European Commission, was that the...
Well, I was hoping that perhaps there was a real-life analogy between a Code Civil and then delegating updates to a different body rather than a parliament or a legislative branch to make it quicker, more quickly to update.
I'm not so sure that is necessarily true. I think it does depend on the area of law and the competence of the EU. But another way of developing codes is very much like in English law, is through commentary and academic commentary, but also the decisions that are developed. And although in civilian jurisdictions there is no precedent, they are taken into account when judges make their decisions. So I'm not so sure that lack of code and being precedent-based is the reason for the success of English law. But what I think is the reason for, or one of the main reasons for English law being so successful, commercial specifically, is the fact that it's very predictable where there is a contract. A bargain between the parties is respected. For example, courts will not very quickly be seen to imply a term into a contract once it's there. There are fewer, by comparison to other jurisdictions, default rules or mandatory rules, rules that would apply irrespective of what the parties say in the contract. And this sanctity of contract, autonomy of parties to decide how they want their bargain, even if it might be unreasonable or unfavourable to one of the parties governed, that willingness of the courts to uphold those bargains, I think, is a good reason why, one of the main reasons, in fact, why English law is so successful. Other reasons, of course, will have a lot to do with institutional context. So judges in the UK are usually senior lawyers, they have high expertise, independence, integrity. Courts are structured in such a way that they work quite efficiently. It's quite good value for money if you think about it, even if you might not necessarily think of courts as operating efficiently in this country. But they are willing to constantly improve. And it's interesting in post-Brexit, the referendum, how is this role of English law going to change? Obviously, no one knows, but there is clear uncertainty, political uncertainty and economic uncertainty, social uncertainty. That's not so good for commercial parties. So that's one reason why perhaps we might be cautious about the role of English commercial law in the future, but also it presents a challenge and makes us think about what is special about English law. Why is English law for commercial parties, big commercial parties in particular, so valuable in England? And it's interesting that in just August this year, the Lord Chief Justice and Chancellor passed a statement explaining why English law is so important and why it's so strong by comparison to other jurisdictions. It's a very brief statement. It sets out a few reasons why they think English law is still strong and not likely to be affected by Brexit. I've put a link on Moodle to the statement. So if you go to the first page, you can see a link at the bottom there if you wish to read it. But it's not compulsory reading, it's just there for you to look at if you wish to. Now, there's another reason why commercial law is academically interesting, and that's because a number of concepts that appear in commercial law are really private law concepts. And you will be familiar with a number of them, from contract, tort, property 1 and 2. So mostly the law is case law based with the concepts that you are in cases that you're already familiar with. And also another reason, very, very practical reason why it's useful to know commercial law is whatever the wake of Brexit might be, the City of London is, and commercial law here is still likely to be going very strong. So it's certainly a wise choice if you are contemplating a career in London as a commercial lawyer to study the area. So we've talked about why do commercial law. Now, how is this going to be run? So I said at the start that lectures are, in term 1, done primarily by me, but also by visiting Professor Richard Cullinan, who will talk to you about contractual interpretation. And he will take 2 lectures later on this term. And in the next term, we have Ben McFarlane coming to do a bunch of lectures, along with Paul Davis, who newly joined us. And there will be 2 revision lectures at the very end, done by Paul and myself. So that's a setup for lectures. There are also tutorials, as you know, 9 of them. Before each lecture and tutorial, there is some reading set. If you look up Moodle, you will see there is reading set before lectures, set as pre-lecture reading. Everyone happy with the prefix? So it's there because I think, we think in the course that it's going to be helpful for you to read certain materials in class. And you have to read that at some point anyway, so you might as well do it before the lecture. That will help you get through the material in the lecture, but also you will feel better prepared for the tutorials. There will be also separate reading before the tutorials themselves, but hopefully that will enable you to think about the material in more depth and ask better questions, be better prepared for the exam ultimately. And we all really want you to do very well in exam because we have a very strong track record of high performance in commercial law, so we really want you to do very well. So that's why this reading is there for you to do prior to the lecture. And occasionally I might ask questions. I don't want this lecture to be a monologue. I would very much welcome questions from you and also comments, thoughts. So I don't want it to be monotonous. Yeah.
Contract is pivotal to this area of law, commercial law, because it's disputes between business parties. What do you think of ATIA's model of contract law? So an agreement between 2 parties and then one party relies. What do you think of that, just sort of that basic approach to contract?
I'm rather a fan of ATIA's approach. I've always thought that. There's also debate about consideration and whether it ought to play a role, isn't it? Right. So I don't agree with those. Trytle, I think, is the proponent of the view that consideration is so important in English law. And I don't think it's right, but it's there. So I think it's important to distinguish perhaps the academic commentary, and especially the legal theory, from the cases and what the courts say. Because ultimately, what the commercial parties want to know when you come to advise them perhaps is what the law is, and the courts undoubtedly follow the consideration approach, right? So they will not engage in arguments about ATIA or
privity and things like that. So will that come up on the commercial exam?
So this helps me to target the answers a bit better. You will not be asked questions from your previous modules. Okay, let's make that very clear. So the exam will be based on the material that we study here. Of course, commercial law, as you know, builds on those other areas. So builds on contracts, builds on tort property. But we will discuss those basic concepts to the extent that they are necessary. So you will, undoubtedly, we will talk about contracts being concluded and contracts having terms. So when you come to a tutorial or you see in the exam a question about a contract being concluded, you will just need to focus on the issues that we'll be discussing here, not about issues such as whether there was valid consideration, whether there was peppercorn or not. Things like that, okay? But if you're ever in doubt, okay, please ask me. I'm the module convener of this module, and I would rather that you ask me and ask me millions of questions. If I can't cope with the volume, then I'll let you know. But I would much rather that you ask and I tell you than you be just sort of, oh, I'm not sure what's going on. And then it's just not helpful to anybody. So the purpose, I think everyone on this course is just so committed to you doing well and having the resources you want. So that's it. That's my advert talk. Done. Right. Where was I? Right, tutorials. Books. No traditional textbook. There is, however, a recommendation for you to read English Private Law, edited by Andrew Burrows, and it's handily available online via Oxford Scholarship online, so the details are on Moodle. You no doubt know that. The book online sets out basic concepts in private law, as the title suggests. And we're not discussing all of this book, and you will be directed to specific sections of it when and if necessary. But because commercial law is based on those basic concepts, it's important to get a firm grip of those concepts before we look at cases in detail. And most textbooks are either outdated or detailed in an unhelpful way or insufficiently detailed. So there just isn't one that would fulfill the requirements for you guys. But having said that, there are a number of commercial law books out there. So there is Good on Commercial Law, now in 5th edition. And in fact, for this lecture, I think I suggested reading a chapter. Don't worry if you haven't read it, but if you haven't, I might suggest that it's a good idea to do perhaps after the lecture. And it's the first chapter from the 4th edition, but the 4th and 5th are practically the same, except for some Brexit discussion, which is not terribly helpful. And you, having done EU law, you probably know a lot more about that than what's said there. So there are a number of textbooks out there if you want to do that as an additional reading, but I would really not suggest that this is the best use of time. I think the best use of time is to do the reading that we suggested before the lectures and tutorials. Come and think about the material, try and ask questions throughout, or think about it and discuss in class. Okay? Does that sound okay? Do you have any questions? No? Right. Okay, so to crack on with the material for today, there are two substantive areas that I'd like to discuss. One is the importance of concepts in general in commercial law and the relationship with context. It's not necessarily examinable material, so don't think about it as necessarily a question that you might come up. It might not. But what's important about it is that we appreciate in what way commercial context is treated throughout the law and how concepts are treated in commercial law. Plus, in doing so, we'll discuss a couple of cases that will be very handy for discussion in sale of goods, transfers of property classes and lectures later on. And the second aspect that I'd like to discuss is the importance of certain basic concepts in commercial law, and that is property and possession. And again, we'll look at those in very general terms, and most of this you already know, so I hope this will be, some material might be new, but some of it will no doubt be just revision. But it's important to appreciate the importance of property rights by contrast to personal rights, and importance of the role that possession plays. And also to think about whether they mean anything different in commercial context, by contrast to family law dispute, for example. Okay? So there's one view on this concepts and context. Can everybody see this okay? Okay, good. So Baroness Hale in Stuck and Dowden, family law case, really, said that context is everything, and domestic context is hugely different from commercial context. So that's one view. But another view is that the law shouldn't be organised in accordance to context, but there's a different way to organise the law, and that's to organise it conceptually, not contextually. Some areas of English law are organised according to concepts such as contract tort, and you are familiar with those already. Others might be family law, organised according to context, art law, environmental law. And in the areas that we're talking about, in commercial law, we are talking about business parties, so not consumers, not individuals entering into a contract, but with a business goal in mind. But the important point is that we are still using concepts, legal concepts, to talk about law that governs the legal obligations and rights between those parties. So the whole point, I think, of concepts is that they are invariant to context. So they're invariant to context, and I think that's the reason why we have rule of law. The rules are there to guide people's behaviour, and they should not be different depending on who the parties are. Where the judge is faced with a rule, they ought to look at the concept, what the rule is, and apply it accordingly. It's not just about the judge coming up with stuff just on a discretionary basis. But the distinctive feature of English law, English commercial law, is that there is no separate, distinct body of rules that would apply to commercial parties and not to private ones. In some jurisdictions you will have separate commercial codes, but again the boundaries between commercial law and other laws are quite vague often. One of the reasons for it is that commercial law encompasses a great variety of legal relationships. You have basic contracts, how it all started, trade, commodity trade, so selling wheat to the baker to grind into flour, to store for the baker, to store it somewhere, the warehouse. So contracts of sale, contracts of storage, these were the starting blocks of commercial law. But now we have all sorts of arrangements that involve intellectual property rights, intangible property, if you like. And a lot of it is now influenced by technology as well. So commercial law encompasses a great variety of concepts. But they should be invariant to context, I think. And a good example of it is the case of Shogun Finance and Hudson. Do you remember this case from contract? Yeah, okay, great. So I've got a little slide just to take eyes off the text for a bit. In Shogun Finance, as you know, we've got a rogue who purports to be Mr. Patel, comes to a dealer to buy a car. And the dealer says, do you have cash? The rogue says, no. How do you want to pay then? And the rogue says, well, I'd like to buy on hire purchase agreement. What's a hire purchase agreement? Anybody?
Pay some money up front and then gradual payments afterwards.
That's right. Who pays for it?
A third party lender.
Mm-hmm. We'd say that's a third party lender financier. Because they technically don't lend money, but what they do is they acquire ownership of the car. So they buy the car effectively from the dealer and enter into an agreement with the person.
Like a mortgage?
You see, no, because in a mortgage, the lender advances the money, the entire sum, against property which they don't own. A mortgage, as we understand in the common speech, against a house, is not actually a transfer of ownership to the lender. So the property aspect is different. But
more of a lien kind of deal?
No, again, so lien mortgage will be a form of security right. But what they have in common with hire purchase is that the financier, the person, the entity that advances the cash to the person who wants to acquire the asset, will take the risk that the person who's buying the asset might not pay. So in this case, the rogue, Mr. Patel, agrees with Shogun Finance, a financier company, that they will pay sums of money over a period of time, equivalent to the value of the car plus a little bit, usually. They will have possession of the car, they'll be able to use it, but the property will be with, the ownership will be with the financier. It's similar to security rights in that it provides a form of reduction of risk for the financier, that in case the person does not pay, the hirer does not pay, they will simply keep the car as their own. And in mortgage, or lien is a form of security right, and there the lender also has, the deal has a function of reduction of risk in that the lender will keep the asset or will have a right to resort to the asset, for example, sell it or take possession of it, if the borrower does not pay money.
So with the mortgage, the mortgagee, rather than the mortgagor, has the equitable title?
Right, I think it could be either. Mortgages could be both legal or equitable, so it could be either, depends on the mortgage. But the nature of the property right, legal, equitable, is not essential to the protection of the financier.
It's secured lending.
That's right.
Secured lending.
In the case of security rights, yes. In the case of hire purchase, the common industry term is not secured lending, precisely because there is no form of security right. And we'll talk about the details of security right later on in the course. But the difference between security and hire purchase agreement, by and large, is that in hire purchase, the financier is the outright owner. They own the car. That's it. They have a right to it. Mr. Patel can repay all but £1 to the financier, and the financier will say, well, pay me back £1. The person, the hirer, might say no, and the finance company has a right to keep the car. With security rights, that's not the case, because the owner, the person with more important property rights, is the borrower, the debtor. By and large, there will be some exceptions, but by and large that's the case. So if you repay 80% of it, you have 80% right, beneficial right, I will call it. I will not call it equitable right, and we'll talk about it later why, that the debtor has. So the financier will only have recourse to the asset to the extent that they are unpaid. Okay? Does it make sense to everybody?
So if you pay 80% of the car money and plus the interest, but then you can't pay any more, the lender can just take the whole car?
In the case of hire purchase, yes. Which is why we don't call the finance companies in hire purchase agreements lenders, because in industry the term lender is kept for secured lending, where there is an actual loan advance of money, whereas even though functionally it's a similar thing, because you're advancing a sum of money to another person.
But once you paid it all, then there's a contractual fulfillment and you get the car, it's yours.
That's right.
Okay.
That's right. It will depend, of course, on the contract, because there might be contracts that say at the end of hire purchase, all you have is a right to get a new car from the dealer for extra sum of money, which is what most hire purchase agreements with consumers are now about. But anyway, the important point is that the finance company, Shogun Finance, acquire the ownership of the car, and the rogue promises to repay. They've got possession of the car, so once the rogue has possession of the car, do they have ownership of it? No? Why not? Someone at the sort of back can tell me. Who's got the ownership of the car? Shogun Finance, thank you. Shogun Finance's ownership, but Mr. Patel, supposedly Mr. Patel, has got the car possession and is a rogue. So what he does, he sells the car to a third party, innocent party, Mr. Norman. And what does the rogue do? What do rogues tend to do?
Disappear.
Of course. Of course they do. So he disappeared. So we've got Mr. Norman, and we've got Shogun Finance. Who has ownership of the car? Shogun Finance, very good. But wait, what about Norman? Norman didn't consent to acquire ownership, to acquire possession of a car that was owned by another party, did they?
It's still conversion, strict liability.
So that would be the tort that Shogun Finance can employ against that party. But the basic question is, the first question is, can Norman say, I knew nothing about it, I'm an innocent purchaser, I can defend my any action that you will have against me, for example, tort of conversion. And they say, I'm a bona fide purchaser. Why not?
No, because as you said earlier in this lecture, the court will only be concerned to uphold the original bargain, and it has less of a view to encouraging sort of good faith considerations.
It's good answer for a slightly wrong reason. Okay, so the good faith defence for Norman is not a good defence because Shogun Finance has a legal property right. They have outright full ownership of the car. They are the owner. Now, and it's true, you could link it to the background, but there are some property rights that will enable bona fide purchasers to raise a good defence. What sort of rights might they be? So, for example, if the car were not held by Shogun Finance outright, Shogun Finance is not an owner, but if they are a beneficiary under a trust, okay, if they are a beneficiary under a trust, what sort of right do they have to the car?
A bona fide purchaser for value, for market value, is or for value, that's a defence in trusts.
It is a defence to what sort of right?
Equitable.
Equitable property right. And Ben might say it's not a property right, it's a persistent right, it's a right against a right. Have you covered that side of the story? It's not so essential here, but it's equitable rights, right of a beneficiary in a trust, will be enforceable against third parties, innocent parties like Norman, except if the purchaser is of legal title, so buys legal title from a trustee, not just equitable, not just right by way of equitable security or anything like that, and they are for value and without notice of the beneficiary's interest. So a bona fide defence can be a good defence to a property right, but to an equitable one, not to a legal one, such as here. Questions?
You could cite Armory and Delamere as well, because there's sort of a spectrum of entitlement who has most right to the car, and it would be Shogun Finance rather than Norman who got it from some guy.
So Armory and Delamere is a finder's case. So if you find a precious ring and you give it to a jeweller, for example, and the jeweller takes a stone because they don't think that it should belong to you, then you can sue the wrongdoer, right? Because you were the first person as a finder to take possession of the asset. But I'm not so sure that this explains equitable rights. It does explain very well legal property rights. But equitable rights are different. And we'll come across legal property rights when we talk about transfers of ownership in sale of goods. So, for example, if I asked you, do you want to buy my laptop for £1? It's an expensive laptop. You will probably say yes, because you could always sell it for more. We agree the deal. The laptop is yours. The property passes to you. That's legal property. I am devoid of any property rights in this laptop, and it becomes yours to deal with it as you please. So we'll talk about, when we talk about sale of goods and passage of property in sale. And we'll also talk about legal property rights that are taken by virtue of security. So we'll talk about legal mortgage, and we'll talk about pledge, which is taken by security right, where possession is taken. But we'll also, in this term, talk about equitable proprietary rights. Not by trust, not by virtue of trust, but equitable security rights. And they are very interesting. So we'll look at those later. But the point for now is that Norman does not have a good defence to a legal property right. However, there is a possible defence that Norman tried to use, and that's by virtue of statute. There's a separate statute that Parliament passed specifically to deal with problems such as innocent Mr. Norman. So in sale of goods, when you buy a car from someone who doesn't have ownership, such as the Rogue, you don't acquire good ownership, and the Shogun Finance Company, in Shogun Finance case, we've seen, is still the owner of the car. They don't stop being an owner because an innocent party bought it. Okay? But there is an exception in Hire Purchase Act in section 27, and it's set out on the handout just there. We'll talk about the defence in greater detail, but what's important is that, for now, is that it applies only to motor vehicles when a person who is a hirer, such as supposedly Mr. Patel, the Rogue, sells the car to an innocent private purchaser, not a company who's dealing in cars, but a private purchaser. And when this happens, that purchaser, the private purchaser, can raise good defence against the financier. So by virtue of statute, by virtue of the defence in the statute. So the question then is there a hire purchase agreement? Is there a hire purchase contract here? Why not? I can see a shake that there is not. Why not?
I think about the fact that the pretended to be someone else and gave the credit details to someone else, or when they credit checked him, then like, they thought they were making contact with someone else, and therefore the identity of that person is kind of crucial to the contract, so it's void for
right, mistake of identity. So the question is whether there's a contract at all. And in order to decide this question, the court looked at the old law, case such as Cundy and Lindsay, which involved precisely this question where a fraudster comes forward, pretends to be someone who's very wealthy, and buys a bunch of handkerchiefs, I think it was, and it then turns out that he was a rogue, but in the meantime the rogue managed to sell it on to somebody else. So the seller is not paid and wishes to claim money or the goods against somebody. The question is there a valid contract in the first place? And you're right that Cundy and Lindsay says, well, if you're fundamentally wrong about the identity of the person, then there is no contract at all. So it would seem that Shogun Finance is just an easy case. I'm just going to the next page. So it would seem that it's an easy case. And the majority in Shogun Finance think it's an easy case. Lord Hophouse, Phillips Walker, particularly Lord Hophouse, says, well, the law is clear. Look at Cundy and Lindsay. There is a fundamental mistake as to the whole transaction. There is no contract because essential to the contract was the wealthiness of the individual making the credit checks. No financier would enter into a hire purchase agreement without having checked whether the hirer is able to pay back or pay the installments that they're promising to do. Since in Shogun Finance all of this, the documentation was fraudulent, the financier was fundamentally mistaken. There is no contract, therefore. Now, the minority feel somewhat sorry for Mr. Norman, and they come up with interesting arguments why Mr. Norman ought to be protected. There are arguments based on comparative law, German law, because in German law, Lord Millett says, in German law there's this wider defence made available to innocent parties buying from those who are not real owners of goods, of property. So, in the keeping with European law and harmonisation of contract law, we ought to allow Mr. Norman to have a good defence. Lord Nichols is slightly different. He thinks about the cases in general and English law and thinks about overruling Cundy and Lindsay. But ultimately, Lord Hophouse is being in the majority, says that none of this is relevant. Yeah.
If the initial agreement between Shogun Finance and Hudson was fraudulent on the part of Hudson, then how can Shogun Finance have a good claim against Norman because their contract was basically vitiated by fraud?
Right. Good question. So, Shogun Finance claims against Norman on what basis? You said it at the very start.
Well, Shogun Finance claims on the basis that they made a valid hire purchase contract with the intermediary Rogue, but then it turns out that this contract itself was based on fraud.
No. So Shogun Finance doesn't claim on the basis of contract. So Shogun Finance claims against Norman.
Basically.
Right. Shogun Finance claims that they have a right to possession of the car, and Norman does not. So it's a tort-based claim. So remember that the financier buys the car from the dealer. So they will have paid for the car, they would have acquired ownership from the dealer. So it's just the hire purchase agreement, the hiring agreement, making use of the car by the Rogue that is fraudulent and therefore non-existent.
So why would you create that kind of statutory exception, that the defence that no one could potentially rely on?
Precisely because in the 1960s and 1950s there was a plague of innocent purchasers of cars. People bought, I mean I wasn't there back then, it was a long time ago, but courts were really having to deal with some difficult issues where rogues came to take a car on hire purchase, then they sold it to innocent buyers. The buyers have no way of checking whether the car is bought on hire purchase or they're buying it outright from a legitimate owner. There is a register of cars, public register, and nowadays you can check in privately run registers like hire purchase information, HPI. You do the HPI check, you might hear about that, or similar, Experian. So there are privately run registers available online. Now it's slightly easier, but it's still not perfect. Back in 1950s and 60s, those buyers, ordinary people, had no way of knowing whether they're buying subject to a claim by someone else or not. And the courts were just ridden with cases where they had to say, well, the innocent party has to pay the full price and they also don't get the car.
So here in Shogun Finance, the court is essentially saying this hire purchase agreement is invalid, push that to one side. Shogun Finance bought this car and it's theirs. End of story. There's no hire purchase exception, whatever, no.
That's right, that's right. So Norman would have been able to rely on the Hire Purchase Act defence, on Section 27 of that Act, had there been a hire purchase agreement and provided the other elements were fulfilled, such as him being a private purchaser and providing consideration. But because there was no hire purchase agreement between this Shogun Finance and the Rogue, the Hire Purchase Act did not apply, and therefore the defence did not apply. Okay? Okay? Any more questions? Right, well I think it's time to take a break, and we'll resume 5 past.